Good morning. My name is Attorney Heather Jones, and I'm a senior attorney in the state of Wisconsin for O'Flaherty Law. And this is our free webinar, Tenant Eviction Defense. I just want to let you know before we get going that I'm a Wisconsin attorney, and I have prepared this presentation based on Wisconsin landlord-tenant law. So if you are tuning in from another state that we service, either Iowa or Illinois, the rules may differ from state to state, but I'll go ahead and get started. I'm sure other people will join as they come on. And we'll just get going with the defense. So as I said before, this is the Wisconsin tenant eviction defense for renters in Wisconsin. If you are from another state and have potential issues with your landlord, or perhaps you've received a notice, it would be best if you consulted with one of our attorneys who provide services in the state of Illinois or Iowa. And of course, we're attorneys, so we have to start out every presentation with a disclaimer that this is for informational purposes only. No attorney-client relationship is being formed by me providing or you attending this presentation today. And the information I share does not constitute legal advice. The content of this webinar, again, is based on the laws and regulations in effect as of today in the state of Wisconsin. And if you remain in the webinar, you are acknowledging that you have read and understood our disclaimers. And with that out of the way, we can move on. So, more and more these days, it appears that people are renting, not buying, just with inflation and home prices being what they are. So the group of renters in every state is growing. And of course, where you have landlords and tenants, you have evictions. So with that in mind, we prepared this presentation to be sort of a general informational presentation for tenants to be a bit more aware of their rights as tenants, and you do have a lot. So every state, of course, has its own set of laws that regulate the eviction process. It's not, something where a landlord could just knock on your door and say, you need to be out by the end of the week, and then walk off, and that's it. There's a certain procedure in place here that must be followed to be lawful and enforceable in a court of law. Now, some states have laws that are more tenant friendly than others. So, for example, in Wisconsin, it's a bit more geared towards the tenant, not to necessarily prevent eviction, but to give them some options should the conditions that would allow an eviction arise. And it's important as a renter to know what your basic rights are. If you do receive notice or even get served with an eviction complaint. So we're going to go through some of the very basic rules and regulations that that cover eviction in the state of Wisconsin. Naturally, this is not a one-size-fits-all kind of deal. Every single situation is just that, its own situation with its own facts and circumstances. So just because you heard one thing in this presentation doesn't mean that it's kind of a boilerplate solution to your particular situation if you were to find yourself in an eviction action. But it's always good to have just a general knowledge base going in as a renter. So as I said earlier, my name is Heather Jones. I'm a senior attorney with O'Flaherty Law in the state of Wisconsin. I have eviction experience both for tenant defense, and I've represented landlords as well. And that gives me a good common ground here to understand what's going on both sides of the situation, which certainly helps me out when I'm in front of a judge arguing an eviction. So basically, sometimes there's just no avoiding an eviction. It's going to happen. And I'll go into some of the reasons why an eviction can happen later on in the presentation. But when you get an attorney involved, it may be that the eviction is just flat out on its face unlawful, or it may be that you get an attorney involved to make sure that you're not punished more than you could be. So an example would be, I'll call it mitigating your damages. So you're going to be evicted, but how much money is going to be taken from you in a money judgment for unpaid rent or damage to the unit? You know, an attorney might get involved on the tenant defense side of that equation to ensure that, yes, the eviction is going to happen, but we want to make sure that the person being evicted isn't held responsible for more than they should be, or if we could find something a little less damaging to them financially as the eviction occurs. So that's something to keep in mind too. A lot of times there's just no avoiding the eviction. And frankly, why would the tenant want to stay? Because down the road, it's probably just going to be nothing but trouble with that landlord. If the landlord tried to evict them, was unsuccessful, well, what will the landlord come up with next month? So that's something to keep in mind too, as a tenant who may be dealing with an eviction. So today we're going to go over a few general topics, as I mentioned earlier. And the first one, of course, is the legal reasons for eviction. I've heard a lot of people in the past, they come to me and they seem to think that the landlord's just evicting them because they don't get along or the landlord doesn't like them. But when I look at the facts of the case and ideally the written lease that they're in with the landlord, I do see that the tenant is in breach of the lease for some reason. So we will go over some of the legal reasons for eviction in the state. And then we're going to get into a really important topic when it comes to eviction, which is the topic of notice. And notice can be proper or it could be improper. And an improper notice isn't going to save you from an eventual eviction, but it might buy you some time to make other plans, because as we all know, finding a place to live and moving can be very expensive, stressful, and time consuming. So if we could alleviate some stress and buy you a little time, that might be something an attorney would explore with you in a tenant defense action. Then we're going to go over how things are handled here in Wisconsin with eviction. In Wisconsin, evictions are handled in the small claims court because the small claims court moves faster. And the purpose of that is to get this done and over with so that the landlord's property, the unit that you're renting, isn't tied up any longer than it should be. So we'll go into court appearances in small claims court. We'll look at contesting the eviction. And then finally, we're going to talk about whether or not it is worth your time and money to hire an attorney to help you with the eviction defense, because sometimes the juice is not worth the squeeze. And I'm talking about a return on investment, you know, the money owed versus the money you would spend on the attorney. That is something you will want to examine when you are looking into possibly hiring legal counsel to defend you in your eviction action. So, as I've stated more than once, there are a set of rules and regulations, laws, statutes, codes, are other words for it, here in the state of Wisconsin that govern the process for eviction. Ideally, there will be a written agreement between you and the landlord, known as a lease, laying out what each party will be responsible for during the term of occupancy and what is considered a breach or violation of that agreement. Whatever you do, and this goes for other contracts as well, not just tenant leases, please sit down and take a few minutes to carefully read the document before you sign it. I know that in the flush of excitement with maybe getting an apartment or a house that you really wanted to live in, you may not take the time to read through the small print and see what you could ultimately be liable for if things go completely downhill. And also a lot of people just send documents through like DocuSign, and you just click through the pages real quick and check mark here and put your signature there, and you submit it and you don't even know what you just signed other than it was a lease. So I'm gonna say it again for the cheap seats in the back. Please take time and read the document carefully. And if there's something in it you don't understand or don't feel good about, You can either discuss that with the person who wanted you to sign the document, or you could even print off a copy and have an attorney look at it and explain it to you. And you would be well within your rights to do so. You don't need to just sign any document somebody emails you 10 minutes after they emailed it to you. So typical reasons for a lease violation are here. And the big one, of course, is that you're not paying your rent. Now, everybody hits hard spots in life. Everybody has unexpected expenses, and sometimes there's a reason why you can't pay the rent. You lost your job, you had a medical emergency, you had to help a friend out of a very tight situation. Now, sometimes if you contact your landlord or apartment manager in writing, you can maybe get a postponement. But the important thing is, if you're not going to be able to make your rent and you want to stay and you can make it up, say, in 2 weeks, you have that conversation with the landlord or your apartment manager in writing so that there's a record of that conversation. Don't go into their office and have a private one-on-one conversation with them, and don't have a phone conversation with them, because if this ultimately ends up in court, it's going to boil down to an issue of oral testimony and credibility, and it's going to turn into a he said, she said kind of thing where nobody has any proof, but the landlord does have a written lease that you signed saying you paid this much on this date. The landlord will win. So if you agree to any kind of rent postponement or modification, get it in writing, and an email or a text message will be fine, as long as you can clearly identify from that message what was agreed upon and why. Smoking is a huge one. If they tell you it's a non-smoking unit and they smell smoke of any kind, either tobacco or marijuana coming through the common vents or from under your door, they are well within their rights to evict you. Furthermore, the pet policy, with the exception of certified emotional support animals or assistant animals that are licensed and trained, if there's a no pet policy and you go out and get a puppy, they can say, get rid of the puppy or we will evict you, and they would be well within their rights to do so. Another common issue is that maybe a single person is renting an apartment there and they have their significant other move in. That's probably okay, but the SO is going to need to go on the lease. You can't have somebody living there who's not at least named in the lease. They might not be responsible, but they have to be identified. The final reason is imminent harm. So it's a little bit complex, and I'm not going to go into all of the details. But if there is a domestic violence or drug-related activity by the tenant or friends or family of the tenant who were just visiting at the time in that unit, and the cops show up and there's a police report, maybe even some arrests, the landlord can evict you, and they can evict you even faster than for any of the other lease violations, because there's a risk of imminent harm to the other tenants. So if you've got maybe friends or family, and this is not a judgment, who might enjoy a little drug use or a little criminal activity, don't have them over if they're going to start a problem, because you could get evicted and it would stand up in a court of law. So the next reason for eviction is non-renewal of the lease. Typically, each written lease contains a provision concerning renewal. Generally, I've seen 90 days prior to the expiration of the term lease as the deadline to renew your lease. And it will tell you what steps need to be taken. You have to send an email or a form letter to the landlord or apartment management company saying, I would like to renew. If you don't do that, you don't get to renew your lease, unless, you know, they're a little bit loosey-goosey and they're like, yeah, that's fine, we'll keep you in the unit, no problem. So every lease, every written lease has a term, typically 1-year lease. So 9 months into your tenancy is usually when renewal rolls around. And a lot of apartment management companies are good about sending out emails, but if you are in a smaller building or a house and you're just working one-on-one with the landlord directly, they may not say anything. They may have forgotten. But the bottom line is that you can ask to renew. The landlord is not obligated to renew. So if the landlord has had you in there 9 months and the lease expires at the end of the 1-year term, the landlord is not obligated to renew your lease. And if you refuse to leave, then the landlord is legally empowered to evict you. This is an issue I've run across several times in my practice as well. Either one, I want to sue my landlord because they won't renew my lease, which you can't do. Well, you can try, but you're going to lose and you're going to pay their attorney's costs and fees. And then the other one is my landlord raised my rent. I want to sue them. They can't do that. In Wisconsin, the landlord can charge whatever they want for rent. So they could charge you $12.50 a month for the first 1-year lease that you have with them. And then they could raise it up to $4,000 a month for the 2nd year renewal lease. And they would be able to do that because it's their property and they can charge what they want for someone to live there. So the landlord opting not to renew your lease is not legally actionable. And the landlord raising the rent beyond what you can afford is not actionable. You would just be wasting time and money. You would be banging your head against the wall trying to take someone into court to force them to rent to you at a certain rate. Now, if the building is part of a federal program where it receives certain tax credits for offering reduced rate or something like Section 8 housing, that's a different story. But typically, landlords and owners who are not participating in any sort of federal credit program can charge whatever rent that they want to charge. And just the bottom takeaway from this is just to review your lease carefully before you sign it and know what your options are at the end of the lease, know what breach is, and know what the landlord can and cannot do. To proper notice. So if a landlord believes that you have breached the lease, for example, for unpaid rent, the landlord has to provide you with notice before they begin the eviction process. So it will go notice, then whatever time frame is given in that notice, and then the landlord will file the summons and complaint for eviction in small claims court. So there's several kinds of notice that are proper that the landlord could provide depending on what the situation is. So I've spent a lot of time talking about term leases because, you know, I'm a lawyer. That's my favorite because I have a written agreement between two parties that I can pull apart and go, you know, take into court. But the month-to-month lease is legal here in Wisconsin. So what a month-to-month lease is it's typically oral. Just an agreement between two parties that it's a month-to-month tenancy. Now, a lot of times, if there was a written lease in the beginning and there's no written renewal lease, it automatically converts to a month-to-month. And there's pros and cons to a month-to-month. A month-to-month is great because you don't know if and when you need to leave. A month-to-month is bad because the landlord can evict you at any time for no reason. Just tell you, hey, at the end of this month, you're out. Bye. So you don't have to breach anything to be kicked out of your unit or your home. So if a landlord has you on a month-to-month lease, they have to give you written notice of 28 days. They usually give it at the beginning of a period. So say the first of the month when rent is due, that by the 28th or 29th, you've got to be out. And there really is no contesting that in court. Like I said, the month-to-month is great because it offers you flexibility. You're not in a written contract where you might be responsible for 3 to 4 or 6 months more of rent if it can't be relet. On the other hand, the landlord can just say, you got to leave, you got to go. They don't have to have a reason. On the other hand, you know, you can leave. You can say on the first of the month, I'm going to be out by the 28th. And the landlord has to say, okay, thanks for letting me know. I'll plan accordingly. So it still has to be written, even though a month-to-month lease can be oral. The 5-day notice to pay or vacate, which is also called a quit or cure, is pretty standard with term leases, and that goes back to you didn't pay your rent. They give you 5 days to pay your rent, and you can stay in the unit, no problem. But if you don't pay your rent within 5 days, you're going to have to leave. And if you don't leave, then they will start the eviction process. And then after that is the 14-day notice to quit. Now, you'll see that is used if within 12 months, you've already had the 5-day notice to pay or vacate. So if you've already been given a written 5-day notice to pay or vacate from your landlord, say in February, and then in July, you paid and you got current and everything's fine, and then in July, you didn't pay your rent again, that's when they'll serve you with the 14-day notice to quit. And they're probably not going to mess around with you anymore because they can't have a tenant who's not paying their rent every 3 months or something like that. Sometimes people sign leases that are for over a year. So let's say you're renting a house and you signed a 2-year lease with that landlord, a term lease, the term being 2 years. In those events, you do get a 30-day notice to quit for whatever breach occurred, either non-payment of rent, pets, smoking, imminent harm, something along those lines. So when the lease is longer, the notice period also extends. Now, the notice period is really for you to either get this fixed or figure out where you're going, because they're gonna evict you if you don't leave. This could be helpful in the event of, you want to avoid having an eviction on your record. In Wisconsin, the Circuit Court Access Program is open to all, and landlords do tend to give it a look when they're evaluating potential tenants. Let's put it that way. So that's something to keep in mind, not just am I being properly evicted, but how will an eviction on my record affect me moving forward as a renter? So there's some ways that landlords, especially people who are new to being landlords, can really mess up the notice. And that is something we could bring to the attention of a judge, but it's only going to buy you some time. If the landlord has a legal basis for eviction, like non-payment of rent, but they improperly serve notice and then file a summons and complaint, it's going to buy you a month or two, because they're going to go out and they're going to get somebody to do it for them who will serve proper notice. And then once the time period given in the notice elapses, will file a new summons and complaint for eviction in small claims. So improper notice is just a way to buy you some time to kind of figure out your game plan. But here are some more elements of proper notice. So we see that the notice must be written. It cannot be a phone call or a face-to-face notice. Typically, I see an email plus an actual paper, hard copy, taped to the door of the unit. That's pretty standard. And the notice has to say how many days you have to cure or quit, i.e. fix or move out. And they have to explain what the issue is. They can't just say, in the event of a term lease, a written lease, month to month, they don't need a reason. But with a term lease, they have to explain how you've breached the lease, and if you still have a right to fix the issue, or if you have to leave no matter what. And then if the issue is non-payment of rent, they need to lay out exactly how much money you owe as of the date of that notice, so that you have the information you need to respond appropriately. So here are some examples of what would be improper notice on the part of the landlord. So a face-to-face conversation or a telephone conversation, the landlord saying, yeah, you got to get out, that's not going to cut it. If the landlord wants to be able to evict you if necessary, the landlord will have to do proper notice in writing. And again, with a term lease in writing, they do have to give an explicit reason that the notice is being served. So again, unpaid rent or other breaches of the written lease that we discussed earlier. And if the notice is being served for unpaid rent, again, they need to give you the exact amount of money you owe on the date that the notice is prepared, so that you have all the information you need in order to either fix it or figure out what you're going to do next, or if you're going to call me and have me help you out. So now that notice has been served, and hopefully if you're a landlord, the notice is proper, what happens is after the time period and the notice elapses, the landlord is then free to prepare and file a summons and complaint in the Wisconsin Small Claims Court. So the Wisconsin Small Claims Court is issues that involve money damages of $10,000 or less and evictions. So as I said earlier, they put the evictions in the small claims court because the small claims court moves faster, and its calendar is a bit easier to get into, because the issue here is also one of property rights. The landlord owns the unit or the home that you are renting from them, and the court wants to make sure that, if the landlord has a tenant that's not paying to be there, that property isn't being tied up any longer than it has to be for a tenant who's not paying, or who's damaging the property, or who's putting other tenants at risk. So it goes into the small claims court because it just moves a lot faster. So what they'll do is the landlord will file the summons and complaint and be given what's called a return date. Now, usually it's a couple of weeks, and during that time, it is expected that proper service of the summons and complaint will be completed upon the tenant. That is usually in the form of a process server asking you your name and handing you the paperwork. Now, the return date is just your opportunity to show up at the date and time and location listed on the summons and say, I contest this eviction, or if you don't contest the eviction, you don't show up. But the problem is that the landlord could ask for money damages at the return date if you don't show up, and they may get them by default due to your non-attendance. So no matter whether or not you contest the eviction or not, you should go to that return date. And then if you do contest the eviction or anything that the landlord is asking for from the court, you will be given a hearing date by the small claims court commissioner. And that could be anywhere from 3 to 4 weeks out, depending on the court's calendar. And if you are having a hearing date, that's when you do want to start thinking about hiring an attorney, because that's when it's going to start to get a little bit more complicated. And there's certain steps and procedures to be followed that you might know, but you probably don't, because you don't practice law. So assuming that you appeared at the return date and contested the eviction or contested the amount of money that the landlord is asking for, you will have a hearing date scheduled out where you will provide testimony and provide any evidence that you have in your defense. So, sir, what are some reasons we can contest an eviction? In general, our favorite thing, improper notice. Now, as I said before, improper notice, we could successfully contest and stop an eviction at that time. That doesn't mean that the landlord won't turn around and restart the process doing it properly. And if the landlord has a strong legal basis for eviction, the landlord is eventually going to get it. So if you're not paying your rent and the landlord gave you improper notice and then filed a summons and complaint, and you go in and you say notice was improper, they can't evict me, the court will say, you're right. And then a month later, the landlord is going to properly notice you, file the summons and complaint, and they're going to have, if you're not paying your rent, every single month that you haven't paid rent, their money damages will increase. So that's something to keep in mind. Once in a while, I will see an invalid lease that has illegal terms in it, but it is an exception. It's not typically the rule. Usually it's a larger property company who has an in-house counsel who takes care to make sure that the leases are legally correct. Another reason you could contest the eviction is maybe the landlord is lying. Maybe you did pay them rent. And this brings me to a very big issue that I've seen in a lot of eviction cases, and I don't know why this is happening in 2024, but there are people out there who are paying their rent directly to the landlord in cash. They don't receive a receipt, and they have absolutely no proof that they gave their landlord money. So if you want a piece of free advice, never, ever, ever give your landlord cash for your rent. And you would think common sense would dictate that's not really going on today, but it is all the time. People are paying cash to their landlords and they have no record that that money was withdrawn from their account to pay their rent. And the landlord will turn around and say, I haven't gotten any money from them for months, while pocketing the money. So never pay your rent with cash, please. There may be circumstances that led to the eviction that are out of your control. And this is an extremely fact-sensitive argument. I can't even really give a good example other than you were illegally detained out of the country for a period of time and could not contact any friends or family here in the United States. Something odd, just circumstances that are completely out of your control that might resolve it informally with the landlord, or might at least buy you some time so that you don't have to move out that week. There may be a potential deal that you make with a landlord to pay off back rent, but unfortunately you didn't put it in writing. That might be something that could be arguable based on maybe other types of evidence you had to present absent a written agreement. But again, if you make any sort of deal with your landlord to pay off your rent or to split your rent payments into 2 dates, something like that, it needs to be in writing for your own protection. You could sit and say to yourself, I've never had any trouble with my landlord, Joe. I've rented from him for 5 years, but it's a lot easier to just do it in writing than to depend on a friendship where money is involved. Then we come to the last and really the only one on the list here with any teeth, and that's called retaliatory eviction. Tenants do have a very strong defense for retaliatory eviction in Wisconsin, and what it is if you are having problems with things like your water, your air conditioning, your heat, the safety of a stairway railing, anything that goes to making the unit or home clean, safe, and habitable for a renter, and you brought it to your landlord's attention and they didn't do anything, so you brought it to the code inspector's attention, and the code inspector came in and inspected the unit or the home and, issued a citation to the landlord saying you've got 30 days to fix these or we're going to fine you. And then the landlord turns around and tries to evict you for that. That would be retaliatory eviction. And a landlord cannot do that. And that would be a very successful tenant side case in these types of situations. So we're coming now to the last question, and that is, should you hire an attorney? And it really depends on two things. How much money is at stake, and what is your situation? Because if you're looking at, I just haven't paid my rent for 3 months, an attorney might be able to help you a little bit, but if you're in a position where you're not paying rent, it might not be in your best interest to try and spend money on an attorney. If your landlord is blatantly lying, engaging in fraudulent or abusive activity, that would be a reason to hire an attorney to negotiate things out for you at minimum. It never hurts to speak with an attorney because you need to know what your rights are. But like I said, if the eviction is retaliatory, you should definitely hire an attorney because there's a lot of violations there that could work in your favor in a court of law. But you do have to balance your return on investment. Like, what is the landlord going to be asking for versus the cost of an attorney? The idea here is that you come out feeling good and like a weight has been lifted off your shoulders, not like I just spent a ton of money to save $500. If the issue is less than $1,000, I would say handle it yourself. If it is above 1,000, I would say you should at least meet with an attorney and speak to them about your situation to make a more informed decision. And of course, we're always willing to schedule consultations with anyone who believes that they have a legal fight against their eviction or believes that they need help evicting someone. We do both sides of that case here in Wisconsin. Thank you so much for attending the webinar. I hope it was helpful to you at some point, and I wish you the best of luck. Have a wonderful morning.